Hi, I am Dr. Dures Fei Tagayuna, and this is your lecture on the liabilities of physicians under medical jurisprudence. Our reference is the book with the same title by Pedro Solis. The factors responsible for the increasing complaints against doctors are many, some of which are the gradual disappearance of the family physician. Traditionally, the family physician is a friend and confidant of the family. He is in close and intimate relationship with all its members and treats the different ailments regardless of the nature of the disease. Specialization abandons the family physician and resorts to what can often be an impersonal efficiency, but unprotected by the armor of friendship. The unethical coaching of other physicians, or what we call the doctor's loose talk, can be a precipitating cause of a majority of malpractice actions, as this was found to be attributed to the unwise comments or criticisms of physicians with regard to treatment given to patients by other physicians. These are destructive criticisms that can initiate suits. Breakdown in communication and rapport. A physician must have a special ability to win the friendship, trust, and confidence of the patient. Even if the result of the treatment was not satisfactory or the desired result was not attained, the patient or the members of the family may not think of filing a suit against the physician if compromising language is used by the physician. Disservices made by the mass media. There is an increasing number of TV shows and movies that depict cases of malpractice trials, which have made the viewing public more malpractice conscious. Many books are also published on the matter, as well as magazines, and all have contributed to a large extent on the increased complaints against physicians, hospitals, and nurses. Malpractice is a sort of disease of society which may appear in endemic, if not in an epidemic form. The increasing volume of complaints against physicians may appear sporadically in the newspapers, but a great number of them appear as a dark figure in statistics. Incompetence of the practitioner and commercialization of medical practice. Some physicians who, in spite of their limited training and bigger desire to earn, may undertake sophisticated procedures in diagnosis and treatment. Some surgical interventions are done by physicians whose knowledge, experience, and training are limited, if not wanting. These conditions increase the probability of injury to the patient. Proliferation of medicinal drugs. One of the obligations imposed on a physician is the use of his judgment on the choice of medicines. How is he able to do so when there are just so many medicines flooding the market and all the manufacturers claiming that they are the best? And eight, changing attitudes of the physicians in the management of his patient. In the past, it would be usual to see a physician sit beside the bed of a dying patient. Today, some attitudes are different. The progress of medical science has also resulted in some potential danger, and the ultimate question is one of balancing the advantages against the risk. Classification of physician liabilities arising from his wrongful act of omission can be administrative, criminal, or civil liability. In this lecture, we will talk about administrative liability, which is the right granted to the physician that is temporarily withdrawn to protect future patients. This is a valid exercise of the police power of the state. A simple reprimand, suspension, or revocation of certificate of registration may be imposed. For the criminal liability, when the act of the omission constitutes a crime, the physician who is found guilty may be meted imprisonment or fined as a penalty. Civil liability. This is awarded against the physician to compensate the patient for the injuries suffered due to the physician's wrongful act or breach of contract. It may also include moral or punitive damages. Negligence is an act, omission, or failure to act by a medical professional that deviates from the accepted medical standard of care. In the following laws, negligence is considered a ground for revocation of license, criminal prosecution, and civil claim for damages. Under the revised penal code, any person who, by simple imprudence or negligence, shall commit an act which would otherwise constitute a grave felony shall be meted a penalty of arresto mayor. Under the Civil Code, Article 20 states that every person who willfully or negligently causes damage to another shall indemnify the latter for the same. And Article 2017 states that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. According to the Medical Act of 1959, gross negligence, ignorance, or incompetence in the practice of his profession resulting in an injury or death of the patient shall be sufficient ground for reprimanding a physician for suspension or revoking his certificate of registration. For administrative liability, the characteristics of the proceedings in the PRC or the Professional Regulation Commission are: one, when the physician is found to be liable for the charge, he will be deprived of his right to practice medicine. There must be, however, presumption of innocence of the respondent. Two, the quantum of evidence to prove the physician is liable on the on the ground charged is merely a preponderance of evidence. Three, the respondent physician shall be entitled to be represented by counsel or be heard in person, to have a speedy and public hearing, to confront and cross-examine witnesses against him. The decision of the Board of Medicine shall become final 30 days after promulgation, unless there is an appeal to the PRC or maybe to the Office of the President. After 2 years, the Board may order the reinstatement of any physician whose registration was revoked, if the respondent has acted in an exemplary manner in the community wherein he resides and has not committed any illegal, immoral, or dishonorable act. What are the grounds for reprimand, suspension, or revocation of the registration of certification as provided for in Section 24 of the Medical Act of 1959? 1. Personal disqualifications, which include immoral or dishonorable conduct such as gross immorality, fee splitting, or fraud. Insanity. Physicians can be compelled to undergo psychiatric examination for mental fitness, and emotional stability are essential traits for physicians to competently practice medicine. Gross negligence is an entire disregard for the indifference or indifference to the safety and welfare of others. Ignorance is a want or absence of knowledge or lack of information, and incompetence is simply a lack of ability. Addiction is the periodic or chronic intoxication due to repeated consumption of a drug, and a habit forming drug may be taken repeatedly without the production of all the characteristics found in addiction. And gambling are those whose results depend wholly upon chance or hazard. Criminal acts: a conviction by a court of any criminal offense involving moral turpitude. Moral turpitude is an act of baseness, vileness, or depravity in private and social duties which a man owes to his fellow men or to society in general. Fraud in the acquisition of registration certificates, such as counterfeiting or imitating any handwriting, signature, or rubric, causing it to appear that the persons participated in any act when they did not, attributing to persons any statements other than those in fact made by them, making an untruthful narration of facts, altering true dates, alteration of genuine documents to change their meaning, issuing an authenticated form purporting to be a copy when there is no original that exists, or intercalating any instrument to make it look like such document exists. Fraud is the intentional perversion of truth for the purpose of inducing another to part with some valuable thing or to surrender a right. Performance or aiding in criminal abortion. Knowingly issuing any false medical certificate as to the state of health, illness, injury, or incapacity of a person by a physician is a crime. If found guilty, aside from imprisonment, the physician's certificate of registration will be suspended or revoked. And aiding or acting as a dummy of an unqualified or unregistered person to practice medicine. It is essential that he whose license is sought to be revoked must be charged with the knowledge that the person whom he assisted or aided was unlicensed and was engaged in the practice of medicine. The following are considered unprofessional conduct: the false or extravagant or unethical advertisement wherein other things other than his name, profession, limitation of practice, clinic hours, office, and home address are mentioned. False advertisements are those which tend to deceive or mislead the public, that which makes an untruthful or impossible assertion, or that which is contrary to the present state of medical knowledge. Issuing any statement or spreading any news derogatory to character and reputation of another physician, especially when such statements, news, or rumor are words which tend to expose the other physician to public hatred, shame, ridicule, aversion, ostracism, degradation, or disgrace, or to produce an evil opinion of one with right thinking, and to deprive one of his confidence and friendly interaction in society, and the violation of any provision of the Code of Ethics as jointly implemented by the Philippine Medical Association and the Professional Regulation Commission. The criminal liabilities of the physicians. There are provisions of penal law where a physician may be criminally liable. Provisions specifically mentioning physician as wrongdoer, such as in the instance of the issuance of false medical certificate, abortion, simulation of birth, substitution of one child for another, concealment and abandonment of a legitimate child, or a failure to report treatment of physical injuries, and refusal to render treatment in emergency cases. The criminal liabilities of physicians incurred incidental to the practice of medicine: criminal negligence and imprudence. Imprudence indicates deficiency of action, failure to take the necessary precaution once they are foreseen. Reckless imprudence, on the other hand, consists in voluntary, but without malice, doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate nor the danger clearly manifest. Negligence, again, indicates a deficiency of perception or when the wrongful act may be avoided by paying proper attention and using due diligence. Violations of the Dangerous Drugs Act, violation of the pharmacy law, like that which prohibits the sale of medical drugs or samples, the liability in the issuance of birth and death certificate. For birth certificates, either false statements and failure to report, and for death certificates, false statements and burial without proper death certificate. Defamation is the public and malicious imputation of a crime or a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. This may be libel, like written defamation, or slander, which is oral defamation. The civil liabilities of the physician. A civil suit filed against physicians and or hospitals is premised on recovery of damages for their wrongful act or of their employees. The basis for civil suits are: 1. Breach of contract, which happens when the physician agrees to effect a cure or obtain a specific result on the patient but fails to do so. And 2. Tort. This is a quasi-delict or breach of legal duty. This is a legal wrongdoing independent of contract. The basis of the cause of action is the negligence or fault of the physician as the one directly responsible for the injuries sustained by the patient. Ordinarily, any malpractice action against a physician is generally based on torts, inasmuch as negligence is usually alleged as ground for injury. Thank you very much for the attention.